Welcome to the Markowitz, Fenelon and Bank, LLP video blog.
When you're asked to be an executor and you've actually gone to the process of actually being appointed by the local surrogate, you really need to get your game plan set up. You need to have a thorough understanding of the legal documents, and the legal documents are your roadmap, basically. It is the decedent's wishes of how you're to dispose of their estate. And understanding those legal documents and what they say, and having a good understanding of the assets that are governed by those legal documents is really, really important. If you happen to have had a personal relationship with the decedent, that probably would have been helpful because you may have had conversations with them, understanding what their personal wishes were, what they're thinking, what their beliefs are, etc. But you need to know where you're going, meaning which assets you're going to be keeping, how do they get disposed of, do they go into trusts, do they go outright to individuals, are you selling certain assets because you need to raise liquidity? There's a lot of different questions, concerns, and issues that you need to be aware of. Hopefully you have a will that you're following. There may be trusts that have been formed. Sometimes they're inter vivos trusts where the decedent created the trust while they were alive and perhaps funded it with assets. And now that they've passed away, there may be a different game plan for those trust assets and the trust beneficiaries. There may be a testamentary trust, which is a trust that's drafted and part of the will. And once the estate's affairs are dealt with and wound down, that testamentary trust would end up being created and then funded. If there's certain folks that are beneficiaries of those trusts, you want to keep them informed and you want to communicate with them. When you're appointed, you're in a fiduciary capacity, which basically means it's your responsibility to carry out the terms of that trust or that will. And you're the one that's ultimately responsible for making those decisions. Hopefully the titling of the assets coincide with the legal documents, because sometimes what you'll see is that someone will prepare or draft a legal document, but the assets that document is supposed to govern were not properly titled. So all of a sudden, that legal document doesn't govern that asset anymore. So the planning process of estate planning, which is an ever-evolving process, is extremely important to make sure your wishes are carried out. And it involves titling of assets, family dynamics, which can always change, asset values, which can always change. And when you see the dynamic of multi-generations in family businesses and relationships and asset values, things inherently will change over time. So the process of the planning needs to be evolving and changing as well.
Thank you for watching. If you enjoyed this video, we invite you to subscribe to our YouTube channel.